Dear followers, today we will speak about the carrier responsibility and the very important development happened regarding to Ever Given ship in Suez Canal. The legal dispute just have started with a case almost $1 billion and it's just a beginning. Please watch this video. Important to mention that on Tuesday, April 13th, 2021, an Egyptian court decided to confiscate the massive vessel Ever Given that had blocked the Suez Canal for nearly a week until $900 million compensation is paid. The Suez Canal Authority chairman noted the court decision doesn't mean an end of the negotiation with the ship's owner to settle the crisis. That amount takes into account the salvage operation, cost of the still traffic, loss of transit fees during the week when Ever Given blocked the canal. Number one, traffic on the canal conduit for 10% of the world trade. Number two, the wages of the owner, operator, and the captain of the ship had created tailback north and south, totaling over 420 ships, with billions worth of cargo sitting in the canal waiting for Ever Given to move. Owners of the cargo on board the ships and on other ships stuck in the canal will likely claim from the ship's liability insurer for losses to perishable goods or missed delivery deadline. Nowadays, the international carriage of goods by sea governed by various conventions such as the Hague-Wisby rules, the Hamburg rules, the Draft Convention on Contracts for the International Carriage of Goods wholly or partly by sea. On another side, treaties of Brussels 1924, 1952, 1969, and the London TI Club. Those rules established minimum obligation, minimum immunities, maximum immunities, and limit of carrier liabilities, and aims at creating one uniform law concerning the international carriage of goods by sea. The period of carrier responsibility, the Hague's rules and the Hague-Wisby rules apply that accordingly to Article 1E. This period lasts from the time when the goods are loaded on the time when they are discharged from the ship. According to Article 4.1 of the Hamburg rules, the period of responsibility of the carrier for the goods covers the period during which the carrier is in charge of the goods at the port of loading during the carriage at the port of discharge. A simple meaning of who is in charge of the goods is given in Article 4.2 of the Hamburg rules. The carrier is not responsible until he receives the goods from the port authority or other third party pursuant to law or regulation. According to Article 12.1 of the Draft Convention, the period of responsibility of the carrier for the goods begins when the carrier or a performing party receives the goods for carriage and ends when the goods are delivered. Conclusion: the base of the carrier responsibility under the Hague's rules and Hague-Wisby rules is presumed fault or negligence plus exceptions. The carrier responsibility under the Hamburg rules and the Draft Convention are also based on the presumed fault, with the exception of deleted nautical fault. The amount of the limits of the liability increased with the development of international maritime conventions. I hope I give you today a useful information. My name is Ahmed Abdulshafe, Senior Managing Partner in AAA's Amira Saqr Advocates in UAE, AAA's Abdulshafe and Saber in Egypt. If you have any inquiries, I will be gladly to answer. Please don't forget to like, share, subscribe. Thank you.